So I've talked before about how when new businesses are getting started, they're often looking for ways to accept money. One of the ways they often do this is by selling bits of the company. And I've mentioned before that if you sell a bit of your company, you're selling securities. And there are a whole bunch of state and federal regulations that you have to pay attention to when you're selling securities. And so lots of businesses, when they hear that, they say, oh, okay. Well, if I get in trouble with securities laws for selling pieces of my company, I won't do that. Instead, I'll get some debt from friends, family, or people who are interested in loaning money to the company. The problem is, under lots of situations, when a new company decides to take on debt to finance its general business activities, those debt instruments are securities as well. And the viewer might be saying, wait, it's a promissory note, it's not a security. It's not so simple. What happens is the goal of these securities statutes are always to protect investors from people who want to take their money and not give much in return. And so from the perspective of the statutes, whether you're selling a piece of equity or you're selling a promissory note, it doesn't really matter. Because in both situations, someone is giving the business owner their money and they're hoping to reap a reward, a return, from either equity payments from the business or interest payments generated from the business's ongoing revenue. And so the securities statutes basically say, even if you call it a note, if it looks like a security, you still have to treat it like a security. Now, there are a couple of ways to solve that problem that work in general. One is if the security has specific collateral, oftentimes, not always, but usually, that can help overcome securities regulations. Or the second way to deal with that is simply to comply, because complying with certain parts of the securities regulations can be pretty straightforward, but generally you need a lawyer to help you register the offering with the SEC and state securities regulators. So the key takeaway is, even if your business is only selling debt, if it's giving promissory notes in exchange for loans, those can be securities too. So small business owners shouldn't think that they're avoiding securities law statutes by only taking on debt financing, because those can be a trap as well. So consult an experienced securities law attorney whenever your business is thinking about doing debt financing as well.